Hey folks, Turbine Guy back at you once again. And today, I'm wearing my handy dandy orange outfit, all set for the Hennepin County Jail. Although I got some extra pockets and stuff, because they only give you the one pocket down there. And the reason I've got this on is in honor of Orono's, Minnesota's, abuse of the contempt process. And their abuse of the contempt process is specifically designed at doing this to my wife and I for as long as they possibly can. Okay? So anyway, since that's what Orono's doing, I want to talk first about the contempt of court and what I read on here and what I see it is. Now, well, when we get to contempt of court, we find, and if we read, it says, upon evidence so taken, blah, blah, if the person is adjudged guilty of the contempted charge, the person shall be punished by a fine of not more than $250 or imprisonment in the county jail, workhouse, or work farm for not more than 6 months, or by both. Now, I keep saying not more loud for a reason, because we don't have to jump right to 6 months in jail for both of us. Right away. Rapists don't get that. Okay? They're trying to right away throw us, deprive both my wife and I of our liberty for 6 months over some poles in our yard. Okay? We're not rapists. We're green energy advocates. So I'm trying to explain that the not more are important words in here. That you don't have to go 0 to 100. You can go 0 to 10, 10 to... You can take baby steps in getting things accomplished. And that's what's allowed for a contempt. Okay? You can do that. You don't have to jump all the way to the end. Now, there's different ways you can get in contempt. You could be in court, I guess, and not testify, and they could put you in jail. Or you can lip off to a judge, put you in jail. You know, we see that on Perry Mason, whatever. But I've seen that when I was reading that if you don't pay your child support, they could possibly hold you in contempt. Well, there's another way, and this is what we've had to deal with, well, 3 times now, is the city of Orono is attempting to claim that we're not following a court order. And, you know, that has never been true in the prior contempt or in this. And that's the hard part about it, okay? We have always followed the orders. That's what we have done, at least to the best of our ability without damaging our property. And unfortunately, that first time the court found it wise for us to damage our property. So, anyways, that's maximum penalty. And then you have the constructive contempt. There's your caveat. Now, I really want you to think hard about this, because in the constructive contempt, it's got a very interesting phrase that I take to mean something, and maybe you will too. Down near the bottom, in the last sentence, it says, well, this is 588.02, power to punish limitation. At the end, it says, when it is a constructive contempt, it must appear that the right or remedy of a party to an action or special proceeding was defeated or prejudiced. Okay, now, this is the thing that I'm having a hard time getting my hands around. If it must appear that the city of Orono's right to have our pole removed was defeated, well, they still have the right to have our pole removed. That wasn't defeated. One way to defeat a right would someone say, that shed, the court rules that's yours, and then someone else knocks it down. Well, you don't ever have it anymore. But if the pole's still there, it can still come out of the ground. So I don't understand, and you're going to find out what they're asking. That's why I'm talking about this now. I'm trying to tie how what I read this works with what Orono's trying to do and what the judges are allowing. So anyways, it must defeat a right or a remedy before you can imprison someone or give them a fine exceeding $50. So, if their right to remove the poles from the property is not gone, how could they go for more than that? That's what's running through my mind. All right. First time around, you know, we all know the story about the larger turbine and how we won at the appeals court and then lost the next time around due to a technicality, and then kind of had everything shoved down our throat, even though we complied. Because we took the pole down, we took the turbine down, we got them off the property as ordered. Okay? That's 2/3 of the order. The other third was to remove the footing. We chopped the top half of the footing off and sliced the anchor bolts and buried the bottom half. Okay, so 2/3 was done. If you look at that, chopping half, slicing anchor bolts, let's say that's 2/3 of that. There's a third left. Well, a third of a third is a sixth. There's only a sixth of the order we didn't comply with, and the reason we stopped was to not damage our house. Well, that wasn't good enough for the judge. I was told the engineering reports were excuses. Then I guess the honorable judge thought it was okay as some sort of punishment that we would have to damage our house. Now, I did go to jail, and I still don't get how I went to jail that time, because their right to have that concrete removed was never defeated. All right, quick aside, concrete is clean fill in Minnesota. When you're filling a hole, you're allowed to put clean concrete in. So I had to remove something that was allowed to be put back in. You tell me. Anyways, that's where we're going with this. Oh, the first time. So now we're getting over to the first contempt. So we had thought we had complied. We had brought engineering documentation to show it, is what we did. And the judge called it excuses. And I know one engineer that was extremely upset, a MnDOT civil engineer, because he does not like his work disrespected. Different story. But anyways, a heroic effort got the footing out by Sunday night. I was put in Friday night. So technically, according to the Minnesota contempt statute, I could have been let out of jail Sunday night. But there's no judge around, and we get that. So Monday, and the inspector wasn't around. So Monday morning, the inspector came over first thing and saw it. Yet the city of Orono refused to contact the judge. Not only that, okay. First, Mr. Maddock, the Orono attorney at that time, I think he's still the Orono attorney, and I personally have little confidence in his ability to lead a city, because he didn't even look up the wind turbine law. It's overriding statute. They lost a lawsuit to us over it, and he didn't even look it up. So he lied and said that we did not comply, when we did comply. I just went through that. You know, maybe a sixth of it was left, but there's a reason we didn't pull it out. Made up his own requirements. After he found out that we had the footing out, you know what he did? He said, well, we need an affidavit from the inspector. Well, there's nothing in the order that said anyone needed an affidavit. All he needed the inspector to do was tell him or give him the inspector's report, which I'm sure he had. But he made him do that, which took all day. And so at the end of the day, I'm still in jail, and I should have been out. Well, the next day I was released at 2 o'clock, and it turns out he refused to contact the court. Because if you read, the above entitled matter came before the Honorable Bradfold, Judge of District Court, the one who thought we should destroy our house, pursuant to defendant's submissions on October 5th, the court gave the city of Orono an opportunity to respond to defendant's submissions. No response was received by 1:30 the next day. Well, why not? Our lawyer was told by one of their lawyers that Soren Maddock went out of town and he wasn't going to deal with any of his stuff till he got back, which meant I was just supposed to sit in jail. And thankfully my wife dealt with that. But here you go, Mr. Soren Maddock, depriving me of my liberty against Minnesota statute, because from what I believe, I read once the contempt is purged, you're supposed to be released. Well, the city knew it was purged Monday morning at 9:30. Why wasn't I out that day? Why did I have to wait another day? Good question for anybody to ask. So that's the first attorney we're talking about, Mr. Maddock, and the first contempt. And what I consider to be an abuse of the contempt process by leaving me in jail. Even if they were right with everything else, they were wrong with that. And I don't know many people disagree. Well, next, we're going to talk about Mr. Shepard and what he's done this time. But first, I want to show everybody what we're talking about. We got a couple of poles here that are clothesline poles that you're looking at. And here's a couple of different pictures of them. Now, these clothesline poles, please understand, my mom never had a dryer in her life. And I'm the green type of guy. I don't like to bake my clothes with chemicals, so I'd rather hang them outside in the fresh air. But I guess in Orono, even though a court's already ruled that after they were installed, the court ruled that clotheslines populated the city uncontrolled. Years later, 5 years later, I get sued by the city for these clotheslines. And these clotheslines are part of why I'm supposed to be going to me, not just me, and my wife are supposed to be going to jail. We'll get to that, who's going. So that's the clotheslines. Now I'm also going to show you a picture of a wind turbine pole. There's 2 of these on the property. And the turbine's been removed per the court order. And that's what the court order stated, wind turbine assembly. It didn't say anything about the footings or the poles. Now the judge decided to change his order in order to help out Mr. Shepard. And we'll talk about that in a minute. But you can see from the picture that there is just a pole and a footing. And I'm going to go back to one more time. How did I defeat their right to have that removed by still having it there? Interesting question. Now we're going to talk about Mr. Shepard. Now Mr. Jared Shepard, I have found, is willing to lie in court about me. Now I heard him do it numerous times on little bitty things, but there's one that really got under my craw. And we're at a hearing about whether or not we're going to be able to depose the mayor and somebody else. And the city has tried this whole time to do everything they can to prevent us from collecting evidence, and this is part of it. And it was court case 27 CV 17 7166, and you can see it was Jared Shepard appeared for and on behalf of the city of Orono. Well, he was talking about a Facebook post I made, and the context of the Facebook post was that I'm tired of the people around here watching me all the time, calling the cops on everything, calling the city on everything, creating a file this thick. Who wouldn't be sick of that? And suing me repeatedly, just like this lawsuit. Who wouldn't be sick of all that? That you're always defending yourselves. So, you know, I kind of said I wanted some people, I wouldn't mind if people were gone. And, like, gone, get out of here, go move somewhere else. About time, leave, right? Well, that's not what Mr. Shepard decided to say to the court. He decided to put his own ad lib on in an intentional effort to sway the court that I'm a bad and violent person. Seeming to think that if he could sway the court to think that if I'm a bad and violent person, we wouldn't be able to depose these people. At least that's what I saw. So what we see between lines, well, 14 to 18 here, and it says, and it's excerpt from Facebook post from Mr. Nygaard, and there's a question to Mr. Nygaard, who do you want gone, question mark, as in killed or whatever. Killed? I never said I wanted anybody killed. I never said that anywhere to anyone in my whole life. But here we got an esteemed lawyer for the city of Orono coming in, and you can tell that I didn't say that, as in killed or whatever, lying to the court, saying that I am a killer. Well, knowing that part of this lawsuit is me claiming PTSD, a non-violent form of PTSD, hoping to capitalize on my disability and the misunderstanding in public that all PTSD is violent, the huge misunderstanding of that. Most PTSD is non-violent. But he's trying to sway the court, connecting dots that don't exist. PTSD, saying that I want people killed. I cannot tell you how much that offended me, that a lawyer from my city would lie to a judge and say that. Where is the honor these days? Mr. Shepard, where is your honor? I have not received an apology or anything from him. It's just normal course of business, I guess. Well, that's not the only thing. He said during the last hearing, when they tried in February, the first hearing, I don't have much paperwork on that now, I'll just give you a quick deal. I followed the court order, I've already made a video about this, word for word. That wasn't good enough. The judge told me I should have known what the city wanted. And we'll talk about that in a minute. And part of what Mr. Shepard said at that was that me, harassed the city inspector. I did no such thing. I've never harassed any of them. I have questioned a few of them on occasion, which I think I have a right to do being a resident, and I pay ungodly taxes here. I think I have a right to question them, and it's unfortunate they don't want to answer, but I've never harassed them. And I'll tell you what, don't listen to me. Why don't you listen to Mr. Pezzo's own words in this little clip? Lawyers?
Yeah.
And that's why I'm not here to give you a hard time. I'm not here to put you
No,
in
and
a
you've
corner.
always been good about that, Jerry.
Well, thank you for that. Okay.
I'm not trying to give you a hard time either. But
Oh, yeah. Now, what I heard was Mr. Pezzo saying that I always treated him respectfully. Now, that's not the inspector's own words. Those aren't my words. Those are the inspector's. Does that contradict with claiming to a judge that I harassed the city inspector? And unfortunately, that's just one of the things that he was not honorable about during that hearing. And it's unfortunate that a city attorney who's supposed to be neutral and help arbitrate things fairly would pick one side against another to the point where they're going to misuse someone's disability and claim them as violent as well as a harasser, which just is 100% not true. Well, this all started because of the extremely incompetent order that Mr. Shepard wrote that the judge copy and pasted. I followed the order word for word. Remove one clothesline pole, remove wind turbine assemblies, clean this up, clean that up. Take clamps off a shed. We weren't even sued for clamps on a shed, but I took the clamps off the shed, right? I followed the order word for word. There's a video about it. There's a link in the description. I'll post it there. And that one shows you the order, everything we're supposed to do, and how I followed it. And the only person anyone can blame for me doing what I did is Mr. Shepard. If he's going to write a bad order, what does he expect? Does he expect the judges to bail his incompetence out? I don't expect the judges to bail his incompetence out. I'll tell you why a little later. So that incompetent order is what has started all of this, because it was so ambiguous that when we got to that February 6th hearing, the first thing the judge would blame me, which I don't know why it's my fault that lawyer is like bad at what he does, but that's what happened. Maybe it's because the lawyers portrayed me as violent. Who knows? Even, that might be one reason. But the judge blamed me and went through the order and realized it was so poorly written that there was nothing he can do. And out of embarrassment, I think, the judge decided to keep blaming me, use my words to rewrite the order, which is why we're here, instead of looking to that lawyer, Mr. Shepard. Mr. Shepard, you have gotten what you've written. I don't know why you're here. If you wanted something else, you should have asked me for something else. But instead, the judge told me, Mr. Nygaard, you should have known what they wanted. How can I tell? It's been a moving lawsuit the whole time. This and that, they don't file proper paperwork. I mean, when we were at this last hearing for the incompetent order to put us in jail, which we didn't go into jail, when we were there for that, ladders came up. I'd never heard ladders being an issue before. Neighbor right there has had a ladder outside since before I moved in. Okay? Now all of a sudden we got to worry about ladders? Like I said, it's a moving target what's going on here. And instead of the judge clamping down and telling Shepard, this is up to you to define for me properly, the judge is blaming me that Mr. Shepard wrote a real ambiguous order that I followed word for word. Crazy. That's why I got this on. Because they're working real hard to get me there. But this time, I think the judge knows it's a little outlandish. So, talk about the incompetent order. Well, when I followed it word for word, is contempt motion in February. Contempt motion in February failed, right? Why did it fail? because he wrote a bad order. Not because I didn't follow it, because he wrote a bad order. So then he files another contempt motion in May. Now, we're going to go through this real quick. And I think I'm going to start out with the judge's order. Here it is. And it says the above entitled matter came before McGill. Oh, wait, no, this is proposed order. Oh, no, this is it. Before McGill. And it's scheduled their order to show cause hearing for May 16th. Orono is against Jay and Kendall Nygaard. Now notice, Judge McGill left out Go Green Energy. Well, I thought Go Green Energy was in this lawsuit. And last time, Shepard included Go Green Energy, and it was rejected because Shepard didn't know what he was doing. So this time, Shepard goes after Go Green Energy again, and it's not included. So anyways, the order says, based on the files, records, proceedings herein, and being full informed in the premises, the court now makes the following. The City of Orono's motion for order to show cause directed to J.T. Nygaard and Kendall M. Nygaard are denied. It says with prejudice because we have till May 1st. That's what we tried to tell Mr. Shepard when he wanted to file these. From what I understand, our lawyer kind of reamed him a new one. Did a pretty good job of it. But Mr. Shepard was not willing to listen to a well-learned lawyer who's been around a lot longer than him, filed this motion, and is dismissed, Mr. Shepard. 2 failures for you now. Abuse of contempt process. You don't know you write a bad order, and then you try too soon. And we're going to look at this quick. Now, here's what they wanted. We looked, the above entitled came before on May 16th. So that's what they're looking for, May 16th. We go to number 4. Defendants did not fully comply with the injunction order on February 4th, and the court held a hearing in the city's motion for contempt. Okay. Well, let's see. The court determined that a contextless reading of the court's injunction order could lead the defendants to a purported confusion about the injunction order. Well, I want to read this, and it's not about here, it's more about the judiciary. And this is frustrating to me, because what I read is that the judge is blaming me for their inability to be specific about what's going on. I mean, the court determined that a contextless reading, well, I'm sorry, Your Honor, I've been in contempt before, and I had 2 different orders that case to follow. The first order said turbine and pole down. The second order said turbine, pole down, and footing. Okay? Well, the order you signed did not say footing for anything. And it said 1 steel clothesline pole. It said other things too, like it said I was supposed to remove a pine tree in the 0 to 70 or 0 to 50 foot setback, which is illegal to the DNR. I haven't removed the pine tree. So I'm a little frustrated that it seems to me that using the words contextless and purported confusion is an attempt to blame me for an inadequate attorney on behalf of the city. Not my fault Mr. Shepard wrote a bad order. Mr. Shepard even tried to correct it in December and got it corrected, but didn't fix it to include anything else. That's not my fault. It's Mr. Shepard's fault. He wrote it. So, let's see what Mr. Shepard wanted. Number 6. At the hearing, it was unrefuted that defendants J.T. and Kendall Nygaard failed to comply with the clarification order. You know, we refute them every damn time we're in court because they don't tell the truth. So, no, he just got to throw that word unrefuted in there because he knows it's refutable. And he knows it was last time because he lost. So, you go down to number 7. Pursuant to the court's inherent powers and statute, defendants J.T. and Kendall M. Nygaard are constructive contempt of court for disobedience of a lawful order, which, by the way, we were not in disobedience. We have complied with the majority of the order that the judge said we should have complied with in the first place, and there's only 4 items left. And the 4 items, there's only confusion because you wrote a bad order. So in disobedience just isn't the right word. Okay. Pursuant to that, what do they say? Well, anyways, saying that we're in constructive contempt, and I know I got 17 here, but it's 16. My wife and I are supposed to go to jail 6 months for the first time we purportedly violated a part of an order. A part. Now that's where I go back to this constructive contempt. More than. They don't have to go straight to the worst case penalty for both of us. My wife's disabled too. She's on disability. I'm disabled. Let's throw 2 disabled people in jail for not pulling poles out of their yard for 6 months. And then, what, do we get to keep the poles then? Because it says, pull them out. It can be relieved. You can pull it out while you're there. But I don't know how that helps. Well, here we go. Defendants may obtain their release upon submission of evidence satisfying the court they have fully complied. Well, how do we do that from jail? The last time we went through it here, they threw me in and gave my wife a month, and she got the job done with a heroic volunteer effort from the community, not including any neighbors, from the community. 6 months. Here, you guys both go to jail right now. Jail. For what? Let's see those pictures again. Some poles. So, now we've seen a few more pictures. There we go, I found it, back in the order section. I'll post it up earlier, but JT is in civil contempt and are supposed to go straight to the correctional facility. Now, the thing about all of this going on right here, all this lying, all this, I call it harassment and expediting. We don't have a meth lab here. I'm not piddling little kids. I don't understand why, if that's the way it's going, that the first thing you could do is go to 6 months in jail, even though you cannot prove that your right has been defeated. So, I think the judge is starting to catch on, because this motion to throw us in jail, boom, it's gone because the judge dismissed it sua sponte. What does sua sponte mean? Here it is. Referring to an order made by a judge with no request by any party to the legal action. In other words, oh, hold on. Latin of one's own will. So he did it on his own. In other words, the judge took it upon himself to throw this crap out because he knew Mr. Shepard was off. He knew he was way off. And here's the best part. This is so bad that the judge threw it out sui sponte. What does Shepard want? City of Orono has awarded its reasonable attorney's fees and costs incurred since December 14th. Which means we're supposed to give him for the first time. He screwed up in February, that he wrote a bad order, that he couldn't throw us in jail. We're supposed to now pay him for that. I mean the nuts. But unfortunately that's a problem. Because as we've talked about in this case, what I have seen is that the court has decided to favor with the city by basically copy and pasting their order. And when the court was embarrassed at what they copy and pasted, now I'm going to go through the order in another video. It is so unconstitutional and bad for many reasons, such as we have an order that says that we can't break the law. I mean, you can't write orders to tell people not to break the law. I mean, at least it makes no sense to me. So the judge has decided that he was so embarrassed about this that he was going to write another order using my language to get me. But now, this time, he sees how ugly it is, and he's starting to see something's wrong. And this is what I want to say to any judge out there. Okay? This now I'm getting on my pedestal. This is what I believe is a libertarian American. Someone who believes in freedom. Someone who does believe in government, as government is needed for certain minor things, not everything like they seem to think. To me, the government was formed to protect the people, or the judiciary was formed to protect the people from the government. The founding fathers did not form a judiciary as an integral part of the government. They formed it as separate. The reason they formed it as separate is they didn't want the judiciary to be acting like it was part of this. And what do you think happens when you got a judge that grabs an unconstitutional order, or one that's so bad and ugly that he's embarrassed here, right? What do you think that happens when he does that? This is what he's doing. That's what I see. And to me, that's wrong. The governments are now protecting, or the courts are now protecting the government from the people. The government does not need protection. They're the one with the guns. They're the one with the jails. They're the ones with the judiciary. The government does not need... We have to go back to the judiciary being about the government, or judiciary being formed to protect people from government. From the government. Okay? To me, this says it all right here. Our founding fathers, if they knew how that turned around, would be spinning in their grave. How hard they worked on it, how hard they worked on everything they did to find out that you get judges that are just rubber stamping, and then when they're embarrassed, then what do? They don't hold the city accountable. That's what I've seen, personally. All right. Thanks for watching. You're listening to, I'm the Turbine Guy. Today we talked about the abuse and contempt process from Orono. Not just once leaving me in jail and taking my liberty, but twice in the past several months. First, over a bad order they couldn't enforce, and second, by bringing it 2 weeks too soon. 2 weeks. Dismissed.